First speaker is going to be Sewell Lee. Sewell Lee is a principal attorney at Sewell Lee Law Firm, PLLC. She focuses on business litigation, real estate, employment issues, and intellectual property. She is committed to helping clients with personalized representation and customized strategies in the business field. With a background in both American and Korean culture, Sewell Lee Law Firm offers a unique skill set to help Korean American companies, as well as companies with different cultural backgrounds, to handle legal issues and business litigation. Our next speaker will be Kumar Vinakota. Kumar Vinakota is a partner at Janik Vinakota LLP. His practice focuses on complex commercial litigation and appeals in both federal and state courts and various administrative agencies. His practice includes intellectual property, business torts, partnership and corporate governance disputes, and insurance matters. He has a holistic intellectual property practice that focuses on developing, managing, licensing, and enforcing IP portfolios. And we are so glad to have both of you here to share your expertise with our members today. Before we begin, we want to let you know that the information in this webinar is for informational purposes only. It's not legal advice. Please consult with your attorney to discuss your individual needs and your individualized circumstances. And if you'd like Kumar or Sewell to become your attorney, reach out to the chamber at info@usicoc.org, and I will be happy to connect you to them. All right, I'm going to go ahead and turn it over to Sewell Lee, who's going to tell us about how to acquire a patent.
Hi, everyone, and thank you so much, Rachel, for the introduction. I'm really excited to make this presentation today. Let's jump into it right away. Today, I'll be talking about, as Rachel said, acquiring intellectual property. If you think about intellectual property, it could be very amorphous. It's a basic idea, innovation, invention that you are trying to somehow make market, sell, license, and make profit out of it. So there are two important parts of it. One will be making this, establishing your invention or innovation to become a right so that it could be actually tradable and can be used in commerce. And that's what I'll be talking about today heavily. So moving on to the next slide. Intellectual property could be a lot of things, but there are definitely four big categories when it comes to intellectual property. One is a patent. It could be a process, machine, article manufacturer. It could be a lot of things. So patent is one category, and I'll definitely talk a little bit more about it as we go on. There is a trade secret, and what trade secret is confidential information which is valuable as long as it's kept as secret. A big example of trade secret is Coca-Cola. They have decided to keep the formula to make Coca-Cola confidential so it could be used, and it's valuable because it's a secret. No one can copy it. The other thing that is well known is trademark. It could be names, logos, trade dress, the slogan for goods and service. Think about logos and names like Chanel, that CC logo on your purse. Or if you think about slogan, Make America Great Again by Trump administration, it's a slogan. So when we talk about trademarks, it's typically when you can immediately connect that trademark with the originator, then it could be a trademark in a lot of sense. So when we hear Make America Great Again, we immediately think about President Trump. Or if we see the CC logo, we immediately think that's Chanel. So those are really trademarks. Copyrights is an expression of idea in a tangible medium. You can think about a lot of art form as a copyright when you put it in a tangible medium like paper, film, CD, MP3 format. So copyrights, a lot of things includes music, movies, things like that, a book that can be turned into a tangible medium. Today, I'll be talking heavily about patent, but these four things can be all intellectual property and a big categories of intellectual property. And as you see how your intellectual property fit into these categories, you can decide what kind of strategy is proper for your company. So what is patent? Patent is a right to exclude others from making, selling, using, or importing claimed invention. And I'm going to talk about a little bit of government policy behind it because it helps a lot for people to understand why the government is giving patent and why certain law exists. Government wants to foster people to have innovation. We want people to invent. We want people to make invention, and that is only possible. It is only possible for us to really progress if we will be able to exchange information in a free format. So government, but you know, that kind of goes against our intuition as to, hey, you know, I spend a lot of money, a lot of resources in creating this invention, so why would I want to disclose it? So in exchange for a right to exclude others for 20 years, that you are giving disclosing the details of your new technology, so the government can give you this right. So, and keep in mind, however, it does not give inventor or owner a right to practice the patented invention. So it does not, just because you have a right to exclude other, doesn't necessarily mean I have a right to use it. So keep that in mind. So why patent invention? It could be a lot of reasons. Number one is it's a good source of recognition of an inventor. You made an invention, you want to put it in a much more established format or in a more concrete right. And patent can be exact that. So you are putting your invention in a format that is a little more recognizable. So that's not one of the one big incentive. The other incentive is it could be a gateway for you to develop a commercial product. When you have it in a very clear format where people can understand what your innovation is or what your inventions is or your ideas, it could actually, you can actually connect, partner up with another people and then make them develop a commercial product based on your technology. Again, and another good thing is protection against competitor. You can monopolize the market a little bit more by having a patent. So what can be patented? So exact legal terms as to what can be patented is anything under the sun, except for abstract idea or law of nature. And this is a very broad form. So it could be anything. It could be a composition of a matter, formulation, mixtures, polymers. It could be a machine. It could be a machine like iPhone. It could be an article of manufacture, films, foams, fiber, process or a method, you know, wafer manufacturing process, encryption, extraction. All these things can be patented. So if that's the category of what can be patented, let's explain a little more in detail as to what is required for an invention to be patented. Number one, it has to be novel. It cannot be, it's not something previously known or used by other, but it has to be novel. It has to be useful. It has to have a known use or produce a concrete and tangible result. Think about time machine. You know, we all know that, yeah, okay, well, time machine, the idea is fun, it's very useful, but it does not give a tangible result. We all know time machine doesn't really happen. Next one is a non-obvious. When we talk about non-obvious, it's a little bit different from novel in a sense. It cannot be a simple combination of patents or known art that will yield a predictable result. So when it's very commonly thinkable for people to combine one or two more ideas or combine it together and come up with a new idea, that's when we call it a non-obvious. So what can be patented? What do you mean by ideas, law of nature, scientific principle? So when we talk about this, we are talking about really a law of nature. So let's talk about calculus. Calculus can be used in so many different formats. However, the calculus itself cannot be patented because it's a law of nature It is something that exists and that is already a scientific principle that is proven. All right, so what are some considerations when it comes to filing a patent? The common thing people think about is how much is it going to cost? How long will it take? Do I need an international protection? Do I want to file provisional or non-provisional? Should I hire a patent attorney or a patent agent? And these are all excellent questions. And this should be coming up to your mind as a business person, okay, it's all balance of cost and the benefit of it. So these are some of the questions you may want to ask your attorney or your patent agent before you file your patent application. There are different ways we can customize it. So it could be, it could suit into your situation and you can get a maximum benefit out of this whole patent filing process. What kind of patents are available? There are 3 types of patents that are available. Utility patent. So for new and useful process, machine, article, manufacturer, composition of matters, any new useful improvement. So I have this little drawings right here as an example. So for example, Apple iPhone itself is a utility patent. It has different features in it. We can make a phone call. You can use an app on it. It has different features. So that will be a utility patent. Design patent is for ornamental design of a product. Commonly used way is perfume bottles. When you see this design patent right here of iPhone, so how it's rounded on the corner, how it has like square shape as a display. The look of it is more of a design patent. Plant patent is when you see a mixture of plants to make it a patent. Let's say I mix strawberry and cherry and make cherry flavored strawberry. That will be more of a plant patent. All right, so I don't know how many of people here have seen a patent, but as I said, going back to the original idea of government policy behind it, the government policy behind it is, hey, you make a disclosure of your invention and I'll give you 20 years of monopoly of this particular invention. So what government want in exchange of giving you a patent is your clear explanation of what your inventions are. So typically patent will have 5 parts. It's abstract, where it's going to be a summary of invention. And so you're going to describe in a simple format what your inventions are. You're going to describe, there's going to have a background of invention where you basically describe why you came up with your invention, what's the benefit of your invention, and then you have a drawing, an image of invention. If it's a process, there will be a steps as to what your inventions are. Specification, this will be a detailed description of your invention, how it works, what they are, how which part acts with what. Claims, and this is one of the most important part, is going to be describing exactly what your rights are. What you can exclude people from using, making, selling is going to be your description under the claim. All right. So who may file for patent? Inventor, a person to whom the inventor has assigned or is under obligation to assign the invention may apply for patent. So it could be an inventor, it could be like employer, it could be someone who bought your idea, could file for patent. A legal representative, let's say your minor child, your 17-year-old came with a great idea, then your legal representative, the parent, can be a person who's filing for patent. We can have a joint inventor. Invention can be multiple people doing it together, and 2 or more people who make an invention jointly can be a joint inventors. Just keep in mind, a person who makes only financial contribution is not a joint inventor and cannot be joined in the application as an inventor. You can own a patent, but that doesn't necessarily mean you are going to be a joint inventor if only contribution you make is financial. If there's anything you need to take away from this webinar today, it's going to be this last slide from me. Bar dates for filing patent. This is the most important part of my webinar today. So please, please, please focus. As I said earlier, government policies for you to disclose information in exchange for patent. But government doesn't want you to, it gives you a timeline for it, which is 12 months. So upon disclosure, you have 12 months to file your patent application. And if you do not do that, the government is going to think that you made a very generous contribution to this world. By disclosing it to the public and not filing patent application within 1 year from that date, you are not going to have a right to file patent application anymore. This is a bar, it's absolute bar. After 1 year, you have no right to file a patent application anymore. So keep that in mind, it's really important. I have tons of great ideas that come to me that a lot of people do not know about, but at the same time, they made some publication, some disclosure at some kind of meeting 2 years ago, and we're out of luck. We cannot file a patent application on that invention anymore. So when we talk about public disclosure, what is that? It's either described in a printed publication anywhere. It could be a small article. It could be your letter to another company explaining your invention. It could be one of those. So any description in a printed publication anywhere. And secondly, publicly used in US. If you gave it a sample to your friends and your friends start really enjoying it and using it all over, that's going to be a disclosure. If you offer for sale in the US, let's say you took it to a trade show, even though there are only 5 people available, if you offer it for sale, that's going to be considered disclosure, and the time starts clocking. So you have to remember, 1 year from disclosure date, you have to file a patent application in between. And of course, not all disclosure necessarily mean immediate bar, but there are other ways we can protect it. Kumar will be explaining a little bit more about non-disclosure agreement, confidentiality agreement, where we can make it a non-public disclosure. But however, as soon as you do your public disclosure, you have to file your patent application within 1 year. Foreign patent must be filed. If you file a patent in another country, your application has to be filed within 1 year from that foreign application filing date. So please keep that in mind. Sorry. I apologize. All right, that's all for me today. And if you have any question, please do not hesitate to contact us. All right, and I'll pass it to Kumar at this point.
Okay, I'll take over. Thank you. Good morning, everyone. Kumar Vinakota here. Let me get my screen up and running for everyone. Hopefully everyone can see that. Okay, so hopefully everyone can see my screen. So again, Kumar Vinakota, and thank you, Sewell, and thank you, Rachel. I'm going to sort of take over right where we left off, which is hopefully everyone has some basic understanding of how do I get some basic IP rights, in this case, patents. But what are you supposed to do with it? And I'm coming from this context of being in a litigation context, where typically what ends up happening is a lot of people realize that they have intellectual property, but they don't even know what to do with it or what it really is a benefit of. And part of the management that we try to help our clients with is to understand, even before you file for a patent application or develop a trademark, copyright, or even kind of encapsulate your trade secret, is what is the ultimate commercial goal for it. Because it's these decisions now that you make, whether you're a startup, a mid-cap company, or even a large company, that could necessarily affect exactly how you're going to operate the entity and also your intellectual property. And I'm going to start with a screenshot from the movie Social Network. I don't know if anyone's ever seen this movie, but it's basically the life of Facebook. And in it, you know, the character playing Mark Zuckerberg seems shocked that the twins came out of nowhere are suing him for $600 million, even though he thought he developed all the intellectual property that was eventually Facebook. And this is exactly what I see every day as a trial lawyer of someone with valuable intellectual property, and they're trying to commercialize that intellectual property, and they have all these roadblocks of people coming out of the woodwork, out of the background, to try to get a piece of that. And I'm going to explain to you why that is. And it's a very interesting kind of phenomena, but we see it all the time in court. So disruptive innovation. You know, everyone hears that word, especially if you're in the startup context. I don't know how many of you in the participant world here are in the startup world and hear that word disruption. I have a very unique perspective of what disruption is as an IP litigator. To me, truly disruptive technologies will be one license, kind of what Sewell mentioned, so for joint collaborations. I hate to say it, it'll also be stolen because you're disruptive and people like what you have and they want it. And the third one is kind of important. It actually caused the market share of older technologies to diminish. And I'll give you a perfect example. When the iPhone came out, the whole cell phone market changed completely. You basically have personal computers in your hand. And so the older technologies were basically, you know, useless. Same thing with when the VHS tape came out and the CD came out, or DVD came out. And so that's another disruptive technology definition for me. And why this is important is because it's always agnostic to any market or field. Innovation it's relevant to any type of technology, but disruption is the same regardless of that. I want you guys to always remember that, because the last 2 out of 3 in my list, you'll always go to court on, okay? So if something is stolen or you're causing market share of older technologies to diminish, either you're going to have to sue to protect your intellectual property, or someone is going to try to knock you off the king of the hill to get back their market share. And that could be either breaking contracts, and it'll be some sort of commercial dispute that will arise typically in that situation. Now, the first one for licensing, you still have issues, right? Because even if you license technology that you may have developed for commercial use, you as the licensor would actually still have the burden to police that. And if your licensee is cheating, you're going to go to court anyway, okay? So not to throw a damper in this world, but disruption to me, you will be in court. And so what are the mechanisms to try to protect you to mitigate the time you have to go to court, or to make sure that you are successful if you actually have to protect your intellectual property? Now, one interesting point here, there's a source that says 9 out of 10 startups fail, and I want to explain why that is. And it has nothing to do with competition, believe it or not. Again, competition is why everyone thinks they need to get intellectual property, but they leave the complete back door open for commercial disputes that eventually make the startup fail, the company fail, or the intellectual property still gets kind of stolen at this point. All right, so just to recap what even Sewell said, what is intellectual property? Again, patents, trade secrets, trademarks, copyrights, and they're intended to keep the competition out. Now remember, what Sewell also mentioned, and I'm going to emphasize throughout here, is that these cover your rights to exclude but not to use. So it should be easy, right? That's all we got to do. But what does this really mean? Well, there are a lot of competing forces that are always pulling at your intellectual property, whichever form it may be, and they're not always aligned. And these alignments are sometimes from what you call friendly sources. I mean, they're not even your competitors, but they have commercial, commercial goals of themselves that may be in competition with you indirectly. And this is kind of important because a patent, we'll use that as an example, is a right to exclude a competitor. But what are your rights to use it, your own technology? And what exactly do you do to protect your right to use? And if so, how do you make sure that your right to exclude also is in parallel with it? Again, these are the same coin, but two flip sides of it. So let's sort of break it down into kind of a Venn diagram. So everyone knows what a right to exclude looks like, even though you don't know that's the legal kind of connotation, right? You have a disruptive innovation, you have a new process, a new application, new product, new source code, new branding, heck, even a new license. You're going to use a patent, a trademark, a trade secret, or copyright to make sure your rights to exclude are protected. But let's do 2 more circles, okay? And these are 2 of the rights to use. Because eventually, if you're going to have a startup, you're going to have innovation, you obviously want to make money off of it. And sometimes if you can't fund it yourself, you're going to actually have to raise capital for that. Okay, and so that could be from accelerators, incubators, angel funds, venture capital, private equity shareholders, et cetera. And so those type of deals actually allow you to use your intellectual property. Now, if you, again, don't have your own funding and you don't have your entire R&D team developed in-house, a lot of times when you're in the initial phases, you're going to outsource even the research and development and the practicing of that commercialization. So you're going to team up with others, right? You're going to R&D outsource. You might have developers, offshore developers in India, for example, prototyping. You may even use university research. You'll have market teams. You'll maybe even have exclusive manufacturing, let's say in China or in India. And you're going to probably have to incorporate others' IP. You may have a joint venture with someone else's intellectual property as the base and your innovation sitting on top of it. Now, these are those two circles on that I just added are the ones that actually cause most companies to fail on their intellectual property. These are the back doors, right? But how are you protecting yourself on the right to use? Those are all the commercial contracts that people take for granted, okay? So again, we talked about the right to exclude, both Sewell and I, on patent, trademark, trade secret, and copyright to keep the competitors out. But if you don't also have right corporate entity formation, founders contracts, funder deals, equity deals, employer contracts, non-disclosure agreements, kind of what Sewell touched on, even bankruptcy protection, university agreements, if you're not looking at how those contracts are also being implemented as you're developing your intellectual property, you're still not protecting your intellectual property or your commercialization. And hopefully that makes sense to everyone. So let me redo these circles again. So intellectual property protection, okay, getting a patent, a trademark, is to keep the competition out. To do commercial contract protection, these are your friends. We just talked about it. They might even give you money. And then you also have funding and equity protection friends also, okay? Now, why did I put these circles kind of like all overlapped? Because at the end of the day, for any company, I don't care what size you are, your business plan needs to sit right in the middle. And that's the tension that you need to balance as the owner of the company and work with your legal, essentially, to balance these interests. Because if you can see, 2 out of the 3 circles are actually your friends that may misalign your balance, and you might still fail as a startup or fail with your intellectual property. For example, going back to the Facebook example, the twins came out of nowhere. Had they had a proper non-compete or a proper release when they left Facebook, then they wouldn't have to, or Mark Zuckerberg wouldn't have to have gone through that initial lawsuit, okay? So does that make sense to everyone? And hopefully when the Q&A, I could further explain that. So one of the things I just want to touch with is part of intellectual property development is how you're going to house your intellectual property. And sometimes you might have to do your corporate formation a little bit differently, right? So we all know about LLCs, Incs, S Corps, C Corps, et cetera. But you also have to consider, I'm not a tax attorney, and so I don't give any tax advice, but one of the things my clients do have to also kind of watch over, especially with India, when they might have some offshoring, outsourcing component in India, is to basically understand the taxes and the offshore profits, where you do your R&D and IP development, how you treat that as an expense for your company, and also your intellectual property, how you treat that as a bucket, as an asset for your company. But the takeaway here is you must have robust shareholder operating agreements to protect your rights to use your own intellectual property. I mean, everyone, I think, hopefully now gets the point. There's rights to exclude, and there's also rights to use. And when you misalign either one of them, you're going to end up in court, potentially. And that's what the whole point of this conversation is here, is how to protect your intellectual property. Now, I'm just going to touch one real quick point, and then we'll turn it over to Q&A, is there was an act in 1980 called the Bayh-Dole Act that Congress passed to basically allow tech transfer between university and private industry. And this is kind of important because a lot of my clients here in North Texas work with SMU and UTD on offshoring and also doing some outsourcing of their R&D. And as part of that, they either get into license agreements with the universities, or they use the university facilities to reduce to practice essentially their commercial kind of embodiment or their prototyping. And that's very useful. We have a very good ecosystem here in the North Texas between private industry. There's a lot of Fortune 100 companies here There's a lot of great universities that are tech-oriented. And then you also have a lot of capital here also for startups and also for venture-backed and also private equity. And so there's nothing that separates us from, let's say, the Palo Altos of the world, or even if anyone's familiar with the MIT world, where you have all three of those component parts. And so I always encourage clients in the point of IP development is to also work with universities. But one of the key takeaways is when you do a joint research or sponsored research agreements to always protect yourself, because universities have competing interests, right? Because they want a right to publish. And remember what Sewell said, if you let this out into the public domain without filing for your patent protection, it's kind of thank you so much for providing for the public domain, but you haven't filed your patents in time, so too bad, kind of. And so one of the things that I always tell folks is use universities. It's cheaper R&D, but also make sure you protect yourselves with their tech transfer agreements because there's going to be strings attached. So I just wanted to kind of throw that out there. And so if there's any more questions about it, I can definitely answer, okay? And then finally, just a fun joke here. Sometimes some patents shouldn't be issued, right? Okay, so we actually have a patent for a powered surfboard. Not even sure how that would work, but that would be a great startup, I think. And then, believe it or not, in 2000, someone actually patented a swing on a tree. I'm not entirely sure how they got that patent, but that would be also a potential of infringement for, I think, most of us at some point. So anyway, with that, I will turn it back to Rachel, and I guess we can start the Q&A if we'd like to.
Thank you, Kumar. And thank you, Sewell, for your presentations. So we are going to switch into our Q&A portion of the presentation. If you have a question you'd like to ask the panelists, please type it into the Q&A box or into the chat box. And then I will read your question to our panelists and we'll get some good answers. So you can go ahead and get started on that. And we'll go ahead and start. We've got a question here from Raj asking, can one patent software algorithms? What do you think, Sewell? I think
not the algorithm. Algorithm is basically mathematic formulas. As I said earlier, it's not really patentable. There is a way to patent software, though. I'm not trying to say all softwares are not patentable. There was a Supreme Court case that came out several years ago that pretty much create a kind of dead end for software, but that is still, there's some way to do it. You have to connect it with a machine, like computer. Have to have different featuring involved in order for a software patent to really happen, but truly trying to patent a software algorithm is not going to work.
What exactly is the benefit of a provisional patent application? Shouldn't I first have a proof of concept and commercial product before I bother filing any patent application?
Actually, no. And I do have when it comes to provisional application, I do have a slide that I prepared for it. So I will, let me give you some idea what they are. It's counterintuitive because people feel like when there's a word non in it, they think the non is really the secondary, but it's the other way around. Provisional application versus non-provisional application. So as I said, the proof of idea doesn't have to be there. You don't have to actually have a sample and that's what a lot of inventor comes in and then tell me, hey, I'm working on my sample, so I'll wait until that thing is done for me to file a patent application. No, as long as your idea is enabling, if it's working, we can file a patent application right away using your idea and putting in the description about it. So you don't need any actual sample. When it comes to provisional and non-provisional, can you see my screen, everyone? So.
Yes, that's good.
Yeah. So provisional application is like a placeholder. Let's say you came up with the idea and you somehow disclose it and today is 2 days before I actually lose my 1-year date. Then you have to put something on the USPTO, otherwise in 2 days you're about to make a nice contribution to the world. So provisional patent application is commonly used for that purposes. Sometimes it's used for a lot of startups when they don't have the fund to do a full-on non-provisional. Provisional application preserves the priority date. Basically, assuming that no public disclosure has been made yet. It's not going to be published. It's not going to be examined, but you have 1 year from the provisional patent application date to file a non-provisional application and start it going. So that's the whole provisional. A lot of people put in provisional and then start commercializing things to kind of see how the market reacts, and then actually commit to non-provisional. And a lot of provisional actually go. A lot of provisional get abandoned as well because people put it in the market and then realize that it's not really marketable.
And
All right.
I'd like to add one thing
Sure.
on the provisional. I always counsel my clients, especially the ones that are about to have a joint venture, especially raising capital or even having some sort of R&D, and they're going to have a non-disclosure agreement. So non-disclosure agreements are as good as policing them. But I always advise clients that if you can file the provisional before you even have the NDA in place, that's the belt and suspenders at that point. So file your provisional, then enter into your non-disclosure agreement. And so you have even an added layer of protection that you basically have already kind of prevented a joint kind of ownership or joint kind of contribution claim later in life, where the NDA won't necessarily protect you. But if you've already staked out with the provisional, then at least that's more proof that, hey, look, this concept was mine. I entered into a third-party agreement with someone else. They can't claim ownership at that point. So that's another benefit of just going ahead and filing that provisional also.
Thank you. Here's another question. I heard that I should have as robust of a patent disclosure as possible. Why is that important? As it seems to me my commercial product won't cover every embodiment. Why should I have disclosure or claims in my patent that I have no intention of practicing?
Because the simple answer is because you never know. It's probably an easy way for me to say it, but your patent, as I said, there's different part of patent as I described earlier, and then claims is what really defines what your invention, what your right is, what you can really exclude. And so in real estate, it would be meets and bounds, and you want that to be as broad as possible, but your claims has to be supported by explanation you put it in your patent application. So that's what we mean by, hey, have as much robust disclosure as you can, because if it's not really disclosed in the patent application, then we're going to use general industry standard. And that changes all the time is one thing. And then that may not really describe what your inventions are. So it's important for you to have all disclosure required for you to claim your meets and bounds later. So people do understand what you mean when it comes to your meets and bounds.
Okay, here's another.
Kumar,
oh, go ahead. Sorry,
Kumar, is there anything else you want to add in?
Yeah, I mean, one of the things you got to also think about long term. Again, people always get confused with patents as a right to use. And because of that, they have very limited disclosure to their commercial embodiment, and they get designed around by the competition very quickly. By having a robust disclosure, remember, if you now start thinking ahead a little bit, it's a right to exclude. You basically might have claim sets on your actual commercial embodiment, but you have the meat for your own design around, so that if some competition comes in, you may have a continuation, or you may have additional patents that come out of that disclosure to block the competition. And so if you kind of think of it that way, that the robust disclosure is not for you to use it, it's more of thinking ahead. How can I potentially block competition? Is why it's advisable to put as much disclosure in now, because then you kind of, if you don't, you lose it because of prior art at that point later in life.
And I think adding into Kumar also, a patent application is not as definite as people think. You file and then there's a continuation, as he said. You can file continuation, you can file CIP, you can do a lots of things with it. You put in patent application, there are patent application that has so many children underneath. What it means is you have invention A, you have invention A plus B, you have invention A plus C coming out from this one invention. And so if you put more information out there, you can make more children, which means you can make more intellectual property available to you.
Okay, here is another question. Should I also file international patents? And what does that entail?
Yes. International patent is, let me share a screen on it. It's really, there's no such a thing as really a straight up international patent. There's no patent that covers all internationally. When people say international patent, we're really talking more of PCT. So whether you are filing an international patent or not is really should be part of your business plan. And good thing about it is there's something called PCT. So it's file a patent cooperation treaty, PCT application, then later designate your country. So if you look at the timeline, after you file your patent, you have 12 months to file a PCT, which will allow you for 18 months to decide which country you want to file your patent application. And it really depends. And as I say here, look at the timeline. It says file local application, and then you file PCT application. You have 18 months to go into a different national basis. And because of this flexibility, the reason a lot of people recommend to do PCT is you never know which country is going to pick up your technology. That's one thing. And the other thing is, if you think in a long-term plan, think about it. Okay, where am I going to manufacture? Where am I going to sell? Where am I going to, license and all that? And when it comes to patent, right? U.S. patent is not applicable in China. Every country has their own patent law, and because of that, just because you have one right in one country does not mean you're going to have a right in another country. And as I said, disclosure, if it has been more than 1 year from the day you disclose, then you lose your right too. So because of that reason, PCT is a nice, nice tool that you can use to hold another 18 months to decide which country you're going to do. I mean, obviously, doing it all 135 countries is not easy. You do have to choose which country is going to be most valuable. Commonly, I see, just a short recommendation, commonly I see a lot of people doing EU. EU has one nice, patent now. And the other country that is commonly I see is China now. Although their protection is not as strong as other country, is our common belief. But at the same time, the patent is 20 years. You never know what's going to happen in 20 years. India, all those countries, even with the country that has relatively, weaker intellectual property protection, 20 years is a long time. You'll really never know.
Well, earlier you mentioned about Coca-Cola keeping their formula as a trade secret, and they didn't patent it. When would you choose not to pursue a patent and just try to keep something a trade secret? How would you make that choice?
Yeah, and that's the benefit of a trade secret is that there's no timeline. Patent application has a timeline. You have 20 years, but after that is a public knowledge. And also, you have to think about there's different strategy in deciding which way you're going to go. And this is something I strongly recommend a lot of people to talk to an attorney who knows what they're talking about. Because you do have to make a distinction as to, hey, is it really possible for me to even keep that trade secret? As you said, Kumar was talking about, hey, you have all these friends who wants to give you money, right? Or who wants to do things together with you. Can they really keep that secret together? Because trade secret is only valuable when you can keep it a confidential information. But once it's out, yes, we can fight everything at the court, but it's out. So that's really a business judgment call, I would say. If you can keep it a secret, and if, the other thing that I would think about is derivative invention as well. You have a base idea and a derivative of it. Can that be valuable or not? I think those can be all standard in deciding which way to go.
Yeah, and let me add to that. I mean, Sewell touched on a really important point is you have to have the infrastructure to keep it as a secret. Does that mean it goes back to those commercial agreements, right? You have to have non-competes. You have to make sure your employees are under really good employee contracts. In general, though, the difference between selecting a patent or a trade secret is contingent on your business plan. A lot of times, if you have an in-house algorithm to make more efficient business processes that you're doing for yourself, keep it a trade secret. Why let your competition know how to efficiently make the chocolate chip cookie when everyone knows how to make a chocolate chip cookie? But you have a very great recipe, okay? And that's the kind of like a very simple analogy. The cookie is going to all look the same, but if you add the flour before the sugar, it tastes 100 times better. Don't let people know that, okay? So there's a lot of practical business decisions on to do that. But then once you go down that trade secret route, it's a lot harder to actually keep it a secret. And so you really need to sort of outline, and this is, we're talking about data privacy stuff. We're talking all the things that you're worried about hacking and getting all that stuff taken out. Because once it's out in the public domain, you kind of lose it. And so that's the problem with the trade secret.
Okay, here's another question. What if my company developed products with my employees and contractors without any paperwork? It was more of a handshake style agreement. Can I still draw up papers now after the fact?
Yeah, and I'll take that. And the answer is yes. And it's going to be a lot more difficult. And believe it or not, as a litigator, I constantly have to track down people all the time to get the releases and the quick claims of ownership. But I mean, that's my Facebook problem, right? I mean, if you are thinking strategically ahead, one of the issues you need to start thinking about is your friends now may not be friends later, okay? Your employees now inevitably will move around. Try to lock them out now, okay, by these commercial contracts. But the answer to the question is, can I get it later in life? Yes. It's going to be painful, especially if you're already in court, because then it's a whole parade of witnesses and what was said when. You have to reconstruct it through emails. And in fact, I'm working on a case right now where that's literally what I'm doing basically doing a timeline of the past 6 years. There were no agreements, but I have to go reconstruct the intent of the parties from 6 years of emails. And so literally is what we're doing right now in one of my cases. And so, however, if we had a nice little contract at the very beginning, I don't have to do that, right? So you see there's more cost associated with it also on the back end. So that's the whole point of this talk, is try to get it right the first time or do your best.
Yeah, I completely agree. I think it's a lot easier to get agreement done between the party and then have a clear understanding what we each want when things are good. When things are good, people actually think very rationally. When you're in a fight, as Kumar said, when you are in a litigation, your emotion can, other people emotion can easily cloud their memory as well. And then the way you see things or just view things are not going to be the same.
Yeah, and let me add one other thing. I want people to really understand commercial contracts that are associated with intellectual property. They're not just check the box because I think I need to have an employment agreement. They're not check the box, I think I need to have a shareholder agreement. They're not checking, that's the fact that I see this every day as a litigator. I know that clients are just checking the box 5 years ago, but they're not thinking really what the box is for. Every commercial contract, you need to start viewing them as a prenup for the eventual breakup with the counterparty, okay? I don't care who it is. When there's two signatures on that, the contract is basically spelling out what happens when one of them breaches or one of them wants to break the contract. What happens at status quo at that point? So if you start now sort of thinking strategically, this is a breakup contract, not a, oh, hey, I got to check the box contract, not pay attention to the clauses, I think people will have a better understanding of what the importance of these are, just like in a family law context when a husband and wife have a prenup for the eventual divorce. And that's literally all a commercial contract is. And so if you're not paying attention to these clauses, guys like me will take advantage of that. We will, because it's like, well, you signed it and you didn't have your protections in place. So keep that in the back of your head also when you're going through this whole process of IP development.
Is there any way I can stop my employees from taking their knowledge in IP to another company? Can I prevent them from doing that?
Okay, I'll answer that too. It's called intellectual property for a reason. I mean, sure, you can have non-compete clauses, you can have assignment of technology under employment clauses, but let's be honest, you know, in the tech world, you can't really stop someone from taking that knowledge. Only thing you can try to do is stop the derivative works, whether it's trade secrets or intellectual property. And you just have to have really good contracts at that point to stop them at that point. And if they do create a competing product, your former employees, and they go to a competition, yeah, I mean, we're going to be in court fighting it out, or you might try to get a license deal out of that. But this happens all the time. In the tech world, in the engineering world, employees bounce around. In general, the more higher level senior technologists that it is, the more likely that you want to have better protection than like your low level engineers, because they're probably just using standard kind of engineering methodology. But the CTOs of companies are types of people you want to make sure you have really good employment contracts and non-competes with. But in general, can you stop them? No, it's a free country, right? Can you put protections in place to help your bottom line? Sure. And then you got to police it at that point.
Okay, well, we're almost at the top of the hour, so I'm going to ask one last question. And that is, what are some of the common mistakes that you see? What should people be looking out to avoid?
I'll start with that, and Sue, you can take over. Stop seeing lawyers as a evil cost, okay? When you get sick, you go to the doctor and you give all your symptoms so the doctor can give you the right diagnosis. Start looking at your intellectual property lawyers the same way, because the more we know, the more we can get you the right track, the right protection, and to help you with your business plan. And so that's usually folks come to us as a necessity or an evil necessity instead of as a team player. So if you start seeing your IP lawyers as a team player, we actually can help you better succeed on what your end goal is. It's the most common mistake I see.
Yeah, I can't agree with Kumar more. I know no one wants to spend attorney fees. I, as an attorney, don't want to spend attorney fees, so I totally get it. But just like there's sales, marketing, you know, technology, a different part of your business, legal should be part of your business as well. And if you do not, it's important for you on a day-to-day business. It's so busy. A lot of business owners have so much thing going on, and I understand that legal is the last thing that you want to think about, but it is a part that you do have to keep an eye on. Look over your process, like where things are leaking. You know, your employees, you know, tons of you, I'm pretty sure, do not have employee handbook, you know, good non-compete agreement, you know, non-solicitation agreement, technology assignment. You know, if you start just paying attention once a month, and then just have a regular meeting with occasionally going over your legal issue, that alone will save you so much money later when it comes to an issue. When you just put it on a back burner, don't think it as part of your business. If you think it as, okay, it's an evil that happens to only bad people, that mindset will really catch you. And trust me, no one in the litigation is that evil. It's really people working so busy, doing things all over, and then later they're caught with the problem and then they have to solve it now. Much more expensive way, in a much difficult way. And you don't want that. So just keep that in mind. It's part of your business. You do have to pay attention. Try to spend a little bit of time, at least once a month is really my recommendation, to kind of go through your, you know, your process. What are the things that I need to make sure that I have a paperwork and all that.
Well, thank you both so much. We really appreciated you sharing your time and your expertise with our chamber members. For our attendees, we are recording this webinar, so you'll be able to watch it later on the U.S. India Chamber of Commerce's YouTube channel, so you can refer back to what they said. Also, if you'd like to get in touch with Kumar or with Sewell, feel free to email me at info@usicoc.org, and I will be happy to connect you. And don't forget, tomorrow we do have our Resilience of India-U.S. Relations at 9 a.m. This webinar you can register for via the link that's on our social media, or you can get the link from our newsletter and you can sign up for that on our website, which is www.usicoc.org. We are so glad that you came today and have a great rest of your day.